Yes, good evening to everybody. Welcome to the today class of the family law that I already made it very much clear on the Friday, not Saturday, that I'm going to teach today the salient features of the Indian Christian Marriage Act of 1872. Yes, so read what I posted on the screen.
Good evening. Silent features of the Indian Christmas.
Yeah, that is over. You read this one. Can you read it?
Yes, sir. 73rd Republic Day. You are cordially invited to join us to express your views virtually celebrating the 73rd Republic Day on Cisco WebEx meeting platform with meeting number 57616234 from 5:30 p.m. to 6 p.m. on Wednesday, that is 26th January 2022. We are proud to be Indian as we have to com- com-
Commemorate.
commemorate this national event so that it would be perpetual to the youth of India and future generation across our country and across the world in general. Professor Dr.
Yes.
Mohammed Saheb Hussain.
Yeah, because now it is very much clear to you that I am going to make it a virtual. If you are free time at the time, then you can join it. If the time would be there, then I can give the chance to you to speak also. Yes, now without wasting the time, let me come to the point of our study. That is the salient features of the Indian Christian Marriage Act 1872. So now let us see the introduction. Marriage generally is the formal union of one person to another as a partners of life. What is a marriage? It is a union, formal, recognized union of one person to another person, partner for life. Here, one person to another as a partner. When you say the partner, one person to another person, that means the partner should be opposite sex of life. Marriage, which includes two people possessing different interests, desires, and needs, is a special association given shape by social rules and laws and significantly affects individuals. So, if the marriage institutions are there where the two people will possessing the different interests, different product, different desires, different way of eating and dressing and needs, and it is a combination of the association given shape by social rules, laws, and significantly affect the individuals. So naturally, of the same type of the people will unite together, marry together. Because if it is one is east and another is west, then the marriage would be a difficult task. Is it clear? Is it
Yes,
clear?
yes,
Good,
sir.
Yes,
good.
sir.
The law relating to marriage vary based on the community. Of course, Christian community marriage is different, and Muslim community marriage is different. Parsi, in so on and so forth. Hindu, that the couples belong. The legislation respecting the solemnization of the Indian Christian marriage is unified by this act. But in Christianity, if you would say conduct the marriage, we can say the solemnize the marriage. Solemnize the marriage. That word they use it. And on 18 July 1872, it was enacted. This is not applicable to the except for the Cochin or Manipur and Jammu and Kashmir. This rule applies to the entire of India. 88 sections in 8 parts. How many sections are there in the Indian Marriage Act? Sorry, Indian Christian Marriage Act of 1872. There are
Eight.
88
Yes.
sections in 8 parts, and 4 schedules became a part of the Christian Marriage Act 1872. So, what are the requirements for a valid Christian marriage? Yes, read this thing which I highlighted here. Yes.
The following are needed to be met to establish a valid marriage, according to the Indian Christian Marriage Act of 1872. According to the section 60 of the Act, the age of the bridegroom must not be less than 21 years, and the age of the bride must not be less than 18 years.
Yes. So now the question comes over there. What are the valid requirement for the Christian marriage? They specifically mentioned if the boy is there 21 years completion of the 21 years, and the girl is there, the bride is there, not less than 18 years means completion of the 18 years. Of course, now there is a movement is there from the Lok Sabha that they would like to at least increase a woman, bride from 18 to 21. That is the proposal they made it, but I don't know whether the 21 to 24 will be changed or not. Still, it is a dilemma because nothing has come out. So nothing has come out of there. Not effective date is not given at that instant. The old one is holds good. The old one is a bride is the 18 years completion of the 18 years, and bridegroom is 21 years. That is the age to get married. So next point is the two parties to the marriage must give the wedding voluntary consent, which cannot be received by the representing evidence or by compulsion or by excessive. Suppose if you want to see that what exactly it is, the two parties, who are the two parties, means bride and bridegroom, to the marriage, they want to solemnize it, must give the wedding voluntary consent. For getting the marriage, give the wedding voluntary consent, which cannot be received by the misrepresenting evidence. When they want to give the valid consent, they should not misrepresent the age factor also. Or there or by compulsion or by excessive influence, it should not be done. That means there should be more than 21 years if the boy is concerned, if the 18 years, more than 18 years if the girl is concerned. At that instance, they will agree together voluntarily to get it, give the wedding consent for the marriage. That is the second conditions. And the third conditions, at the time of the marriage, no party can have a living partner. At the time of the marriage means either the boy or a girl or a bride or bridegroom, they should not be get married and having a living partner. That is the another point. No party can have a living partner. Suppose if a party is having a living partner, if they go for the second marriage, Salman is the second marriage, and the second marriage is a void because there is a living partner while they are get married the second time. Any one of the spouse. Is it clear?
Yes, sir.
Yes, the marriage must take place in the presence of an official who is allowed to issue a marriage certificate, and at least two credible witnesses are there. Generally, when you see in the Christian marriage, they go to the church. It is the father or the priest or anybody, a diocese or clergyman or any other person who is officially designated. And of course, the government also give the certificate to him to get it to solemnize the marriage of different churches. It will give it. So there should be one father or one parish or one clergyman or one priest would be there, and who will make the conduct the marriage proceedings, and there should be two credible witnesses are there for the solemnizing the marriage under the Christian Marriage Act. Yes, individuals authorized to solemnize the Christian marriage. Can an individual also authorized to solemnize the Christian marriage? Then that Indian Christian Marriage Act, certainly certain individuals are appointed, yes, for the solemnization of the marriage under the act. Under this act, when you write the act, it should be capital letter naturally. It is defined under the section 5 of the act by a person who has received the episcopal ordination. Of course, this is one of the baptism, like the baptism, and he is authorized following the rules, rites, and ceremonies and customs of the church, of which he is a minister. Of course, he should be one of the member in the minister in the church, and he should be baptized, or episcopal ordinance should be done to him, and he may be authorized to conduct the rules and ceremonies and rites, customs in the church. And that person can also be given a license to solemnize the marriage. So next is in compliance with the laws, rituals, ceremonies, and customs of the Church of Scotland, of course, Roman Church, Scotland Church. So the different church would they belong it. So the church, the rituals and laws and ceremonies should be followed. Yes. Do you have any idea in the Christianity also there are different type of the churches are there? Can you tell me anyone? Yes.
Pass on, sir. Pass on.
Don't
Roman Catholic Church, Evangelic Church, Pentecostal Church. Have you not heard any time?
No, sir.
You did not see the board anytime in the church's boards. Anyway, these are the different type of churches are there, and there the rituals and laws and ceremonies are different. But there also a clergyman or a priest or the father who will given the license by the act to conduct or solemnize the marriage. So that is the next point. By a person who is a minister of the religion, yes, he should be a minister of the religion who is allowed under the act to solemnize the marriage with a warrant. Of course, there would be a warrant would be given or an issue, authority would be given. Then, in the case of emergency, he can conduct the solemnize the marriage. By a person who is allowed under the act to issue the marriage certificate to Christian in India. So the act allow the person to issue the marriage certificate. Yes, a marriage certificate will be issued by the place where the marriage is solemnized, and there the priest or father or the person who is got the episcopal order or he is baptized person and who is a minister in that particular church having authority to issue the
Marriage certificate.
marriage certificate. So the if you happen to see the Marriage Act, the Indian Christian Marriage Act, it will be given in under the sections who can be and who cannot be. So that was it is stated over there. The next comes the time and place of marriage. Generally, marriages are the daytime or nighttime. Yes.
Daytime, sir. Daytime.
But the Hindu marriages are night 3 o'clock, night 4 o'clock p.m., night 2 o'clock, or morning, or early hours, and so on and so forth, because it depends upon the horoscope. Am I right?
Yes, sir.
Sir.
జాతకాలు గలవారు అంటారు కదా. So that was the thing. Muhurtam, Gadi, Tedi, at that time they will tie the.
Not.
What is that?
Not cane voting.
Marriage thread. Mangala Sutra here you can say in the Telugu. So next, now let us see the time and the place of the marriage. The Indian Christian Marriage Act clearly specify where and at what time Christian marriage should be take place. It is decided by the two parties. And between the time frame of the 6 in the morning to 7 in the evening, generally that is the time period would be given morning 6 a.m. to evening 7 p.m. The time of the Christian marriage ritual must be scheduled. So on that in the time schedule only the marriage can be fixed. A church or a chapel, yeah, sometimes we say church, sometimes in chapel, sometimes we can diocese. Something is the location where the Christian marriage has to be performed. Some special considerations and requests are granted that gives the time and place for the marriage ceremony to be flexible. So some special consideration or requests are granted by the church and to see that the marriage would run in a flexible manner regarding the time and place. So generally the marriage will take place in the church. In case the church is more than 3 miles from the place where they are residing, at that instance, they can choose any other place also, which will be to conduct the marriage. That is one of the provision of the Christian Marriage Act says. If you happen to see it, you will come across that thing also. A marriage can be conducted in a private place also where the church is not less than 3 kilometers from the place where they are residing. Are you following me?
Yes, sir.
Yes,
Yeah,
sir.
you go through the Bear Act and you will come across that what I said. Okay? Say yes.
Okay, sir.
What is the time?
Yes, sir. 5:25, sir.
Repeat. What is the time frame?
Time morning 5 to evening 6, sir.
No, morning 6 to evening 7. Not 5. 6 a.m. to 7
Morning
p.m.
6 to evening 6, sir.
6 a.m.
Evening 7.
Is it clear? 6 in the morning means a.m. 7 in the evening means
PM.
p.m. What is the p.m.? Prime Minister? What is PM?
Prime meridian.
What is AM? Anti-meridian. Post-meridian, anti-meridian. Okay. Now, where is the place of the marriage?
Church, sir. Church.
Generally a church. But in some cases, with a special provision, and it can be also conducted in a private place where the church is more than 3 kilometers from the place where they are performing the marriage, or houses are there. Okay, that also you can add it if you want to add. Formalities and procedures. Section 12 to 26 of the Act. When you are writing Act, never write the A small letter. Act, always capital letter. Talks about the process involved in the solemnization of Christian marriage. Don't say conducting the marriage. No. Solemnization of the Christian marriages. Number one, notice of marriage. Section 12 of the Act includes written notice from any side, either from the bride or bridegroom side, in the manner provided for in the first schedule of the Act. There is a schedule I told you. In the first schedule, it is given the manner how a notice can be given by the minister concerned. The parties would like the union to be solemnized. The note must include a name and occupation, and residence of all parties, the period of time during which the party involved was concerned, means how many days together they are at one place and thinking to conduct the marriage, the period of time during which in the place where they are involved was concerned, they have lived in their place of residence or the church or private dwelling where the marriage has to be solemnized. They say that at least 6 months they should have to be present over there before they are conducting or solemnizing the marriage in the particular church, in the church jurisdiction. Then the marriage register is allowed by section 16 of the Act to include the notice in any. So whenever the notice would be given to the church, it will be recorded in the marriage register also. So and so person, so and so thing is going to marry. If anybody is having an objection, they should have to bring to the notice of the priest on or before. Of course, they will give some time. I believe it is a 1 month time, if I not be mistaken. There's some notice would be given over there. Within that, if anybody is having any objection, they can bring to the notice of and these notice also will be pasted in a conspicuous place where people used to see, generally in the front entrance. So a noticeable position of this office, the senior manager registrar, for senior manager registrar, on other hand, is expected to forward the notice for such a fixation to each marriage register in the same district. Once it is pasted over there, after some time later, all will be accumulated within 3 months or within 6 months, it will be sent to the marriage register. If once it is over, of course, they will send the copy of the certificate as well as the notice also they will submit to the register of concerning area, jurisdiction where it comes. So that was the thing regarding the notice is concerned. Next is declaration. What is the declaration? Section 18 of the Act allows each party to the marriage to appear before the minister directly and to announce that there is no impediment to the marriage of the parentage or affinity that required consent have been received, mandated by statute. So what is the declaration should have been given by both the parties? Number one, they are sound mind. Number two, they are not, what I say, less than the age of the majority, and there is no impediment. What impediment? Like the brothers and sisters, close affinity or same blood, they are not supposed to get married. So even that consanguinity will be taken into consideration, and thus the marriage will not be conducted. If there is impediment or if there is any obstacle or affinity would be there in the relationship between the two parties, and that required consent have been received, and the consent which is received also be not with the coercion, not with the undue influence or actional force, or keeping the revolver at the
Temple.
temple with a zero range. So it not with that such a coercion would be there. That's my point. Then issue of certificate. So Section 17 of the Act notes that any party to the marriage has been given the minister without warning, and after either party has been given the minister. So these are the things we should have to come into the picture when you want to say. So each party should have to give the each party should have to given such a notice. That is a very much important factor according to the Section 17. So the minister shall, having made the declaration required pursuant to Section 18, give the parties a certificate. Once it is no objection, no affinity, no consanguinity, and everything is very clear, no impediment, and the notice of period is also over, and they solemnize the marriage at the stipulated time and place, then they will issue the certificate also. So, having made the declaration required pursuant to the Section 18, give the parties a certificate. A certificate can be issued only after the expiry of the 4 days after the receipt of the notification. So, expiry of the 4 days after receipt of the notification, provided that the issuance is not prevented, that the parties have shown to the satisfaction of the minister there is no legal impediment to the issuance of the certificate. See, once the notice and declaration will be given to the priest, then naturally, if any impediment would be there, it should be brought to the notice of the church. If not, if the church finds that there is some affinity, some consanguinity, some impediment would be there, then they will notice it and please give the explanation for this regard. They make an objection and give in writing. So if nothing would be there within the 4 days, they have to issue a certificate stating that, okay, now you are allowed to get it married. Solemnize the marriage in the so-and-so place, in the so-and-so church. Once this issuing the certificate will be given to him, within the 2 months, they have to solemnize the marriage. In case once the certificate is issued to get it married by the couple, no, issued by the priest to the couples or one of the parties. Once the notice is certificate is given, within the 2 months they are to solemnize the marriage. In case if they lapse the 2 months, again fresh notice should be given. I don't know whether you got my point or not. Yes, whether you got my point.
Yes, sir.
Sir, I am the online sir. Later I will speak to you. Okay. So always whenever you want to get it married, that you have to give the notice. Who? Any one of the party from either from the bride side or bridegroom side should have to give the notice to the a concerned church where the priest is there, or where the baptized person is there, or episcopal order given church, means given by the act to perform the marriage, to solemnize the marriage. That power is given to that person. At that instance, you should have to see that and keep that in a conspicuous place. And 1 month time would be given, because if anybody makes an objection, that objection could be the party should have to give the explanation for that one. If once there is no such a thing would be there, then after some time they will issue a declaration. You have to give it. There is no impediment, no affinity would be there. Once if it is given over there, they will church will observe it. Then they will give the certificate stating that yes, now you can be allowed to get married. But that certificate is valid only within 2 months. Within 2 months, if you don't solemnize the marriage, then a fresh notice should be given, fresh declaration should be made. So fresh again we have to start it. That is what I want to convey to you. Is it clear?
Yes,
Yes,
sir.
sir.
You have to read the Indian Christian Marriage Act, at least some provisions which I highlighted here, so that you could have a broad spectrum how the marriage will be solemnized. Is it clear? Yes.
Yes.
Section 20 requires any individual allowed to agree pursuant to the Section 19 to bar the issuing of the certificate pursuant to the Section 1 by supplying the minister with a written notice. So there are conditions are there. How you have to give the individual agree to pursuant, what is the bar issuing the certificate, and all the conditions they have to fulfill it. Without written notice, one should not, without written notice to the church, one cannot conduct the marriage. One cannot solemnize the marriage. Section 21 specifies that is a notification pursuant to the Section 20 has been received. Yes, the notice is received. The minister shall suggest that if she is assured upon inspection that the person preventing the marriage is not allowed to do so. If there are any objections should be there, it should be brought to the notice to the one of the party by the priest, or she does not grant a certificate, and why he is not granting the certificate, the reason should also be shown to the parties. Solemnization of the marriage that is said in section 25 of the Act specifies that it is specified that after the issuance of the certificate under section 17, the minister is entitled in the presence of the two witnesses. Once the certificate is issued over to the parties, yes, they can get further get it. They can let they solemnize the marriage. At that instance, I told you now within 2 months they have to do it. If they don't do it in the 2 months, again fresh notice should be, fresh declaration should be given. Again, the fresh certificate of will be issued by the church is must. So now the section, so how the solemnization of the marriage, which is stipulated in the section 25 of the Act, specify that after the issuance of the certificate under section 17, the minister is entitled, how? In the presence of the two witnesses, to solemnize the marriage between the parties in accordance with the form or ceremony which the minister might find it to adopt. So two witnesses are there, and the person who is solemnizing marriage is competent enough. He is get the license from the Act. He is authorized to conduct the Act, and two witnesses also, they should be sane and have the capacity. Whether the two are male or female, it doesn't make any difference, either male or female. But when you come to the matter of the Muslim law, there is a restriction would be there. Either two male or in the Muslim law, the two witnesses must be there. Either two males or are you
One
sleeping?
female. One female.
One male, one female, sir.
I repeated twice. I repeated the question. In the Muslim law, there would be two witnesses and one either two males or are. Why you are just keeping quiet? If you don't know, you say, sir, pass on.
Pass on, sir.
In the Muslim law, there should be two witnesses. Then at least either two are male or one male, two female, but in any case, not four female. I told several times. I don't know why you are forgetting. In the marriage, two witnesses in the Sunni law, but in the divorce, two witnesses in the Shia law. Must. But here, two witnesses are there, whether the male or female. In the Christian Marriage Act, two witnesses are necessary, whether they are the male or female.
Male.
There is no such a specification. Are you following me? Either two female or one male and one female or two male. But not
Yes, sir.
a boy or a girl, because they are minors. Okay. Section 26 of the Act specifies that if the marriage is not solemnized within 2 months of the date on which the certificate referred to in section 17 is given, the certificate is invalid. And the parties are not entitled to have the marriage solemnized without having a new certificate issued under the section 17. Just before I told you, once the church has issued the certificate, yes, they can solemnize the marriage now. From the date of the certificate, within the 2 months, that is the validity of certificate will be there. If not, again, if the 2 months are expired over there, you have to apply the fresh notice, then fresh declaration. So again, the formality should be fulfilled over there. Are you following me?
Yes, sir.
Yes, sir.
When a visa is issued to the people, those who want to fly, there is a stipulation is there, 3 months time would be given. Of course, it depends upon the country. But generally, 3 months' time. Within the span of 3 months, you can fly. In case you could not fly it, again you have to apply for the visa, or you have to show the reason and extend your visa. Sir, where is the question? First, we did not have the passport. No, sir. Where is the question of visa? Have you? Are you having your passport?
No, sir.
No, sir.
Please make your passport have a better vision. Take the passport. If you fly or may not fly, that is a different issue. But take the passport and think to fly, and that to be the government money, not your own money, not your spouse money. Are you following me? Are you following
Yes, sir.
me?
Yes, sir.
I also have the same desire, because whenever the plane goes on the sky, I would always think that one day I would like to fly, but not with my money. But it is a government money or other parties' money I would like to fly. Not only myself, my wife and children should fly, not with my money, with the other party money. Means you get the employment, then you will be allowed your visa, and you will get the ticket for your wife, that is called spouse, and 4 children below the age of 18 years. 4 children below the 18 years. If the once the children are more than 18, you will not get the free. And that to be either 1 year contract, 1 year you will get it. The 2 years contract, every 2 years you will get it. But in Saudi Arabia, mostly the 1 year contract, yes, they will get it in 1 year. Every year they will get the 1 month paid leave and the visa as well as the ticket for the all people. Of course, depending upon the status of the employment, some people will get the executive ticket, and some people will get the business class ticket, and some people will get the economic class ticket. That will be specifically mentioned in the contract itself, which type of the ticket that you are going. Sir, what ticket may be there? No, sir, we are reaching the destination. No, sir. Are you following me?
Yes, sir.
Yes, sir.
How many classes are there in the plane? Sir, we never board into the plane, sir. That's why we did not know how many classes are there in the plane. Just before I told you, repeat, sir, we did not pay that much attention when you are delivering the lecture, sir, because you are so fast. You are so
Business
fast.
class, sir. Economic class. Business class.
Number one, very when you go directly, you enter into the near to the cockpit, near to the what is the pilot door. The first and foremost comes to you in the beginning, not the tail. I'm speaking about the nose. Are you following me?
Yes, sir.
As soon as you enter from the nose side, where the left hand side you will find the pilot's room is there. In the right hand side, the first and foremost you will get it. Of course, first and foremost you will get it the toilet also. Sometimes the toilet will be the front, or sometimes it will be the back. But mostly the toilet will be the in the beginning only. So as soon as you get it, now first is the executive class, and where it is a sofa type chairs are there, not chairs. It is the sofas are there, very wide, and I'm sure only one this side, one this side. That's all, not more than that. It hardly is 10 or it's not more than 10 or 12 would be there, depending upon the plane size. So once executive class is over, then the business class would be there. It is not that much sofa, but it is a very cushion and very nice, comfortable seats would be there. And that is the business. That later on the part, till the tail, all is the economic class. See, whether it's economic class, whether it's executive class, whether the business class doesn't make any difference, because all are going and reaching the destination in the same place. But only one comfortable thing is there, no? The executive class and the business class, the air hostess is more beautiful than the economic class. Sir, how could you know it, sir? It is obvious factor. Those who are serving would be there, no? No, of course they are all almost all the same air hostess, and only the difference is the eatables they have given a little difference would be there from their serving and our serving. But most of the time, the same serving would be there. But a special provision would be given to them. A special identity would be given because their cost is more and our cost is less, economic class. But everybody will reach the same destination. But anyway, it doesn't matter. But have a desire for the economic class first. Later, you can think about the business class. Later, you can think about the
Executive. Executor class.
Yeah, that's why that you have to make it out. I'm sure that one day that you may fly. Of course, I have prepared the another file also, but it's almost all the same on the lines. It is there. Of course, which I now spoke is very in detail length, and this much is enough. But I would like to show the bare act also, because there is a Christian. I see the Christian. Where can I make the Christian bare act? Classification. Where can concept conversion? Christian. I don't know where I put it. There is a bare act also. If you happen to see, Indian is there. No, that is the point. Indian is there. Times Indian. Oh, the Indian Christian, that is actually the Indian Christian Act. So it is under the or Christian. But anyway, that you can happen to see it, you can read it, so that you could know all the provisions. If you type it also, you will get it. No matter. We need not to search over here, because I already downloaded the Indian Christian Marriage Act or Christian Marriage Act. So not the CD, classification, concept, conversions, catalyzer, doctrine, and Indian inheritance, no, nothing. Anyway, that you check it, the Indian Christian Marriage Act of, if you happen to see that, you will get it in the Google search engine. You need not worry it. You just type in the Google search engine, you will get it. Instead of wasting time, then you can make it in this way. Yes. The Indian Christian Marriage Act. This much is enough. 1892 in that right. It's a bit slow. The server is slow. Anyway, that you can check it. With this, that I would like to stop my today's lecture. And tomorrow, what is the next tomorrow? Because if you see the syllabus, yes, here is the syllabus. And today that we dealt with the Christian Marriage Act 1872, it is over. Then we will see the salient feature of the Divorce Act 1869. We'll see the tomorrow class. And when you come to the class also, you read and come to the class. Are you with me? Are you with me?
Yes, sir.
Bhaktullah.
Sir, thank you, sir.
Yes, sir.
Whether you have slept, because nobody is giving the answer to my
Yes, sir.
question. When you are coming tomorrow, that you read some of the provisions of the Divorce Act of 1869. Okay? With this, that I would like to stop my today's class, and I will stop sharing. Then end of the meeting to all. Have a